the two issues are linked, I think, in contemporary political history, seen as a twin-barreled attack on democracy. The reasons for this, I think, are purely a matter of time. The bill was around in 2008, it went away, it came back just at the same time as the media tribunal issue was starting to boil. And people have now inevitably started to think, well, somehow they're linked. In fact, they've gone so far as to suggest that the Protection of Information Bill contains propositions for a media tribunal. Rather embarrassing. Including, I showed you this, the bill must be read as a whole. You must actually read it, okay, particularly before you venture into print on the topic. I've got some wonderful examples of really embarrassing, people really embarrassing themselves, including Andre Brooks. Let's talk more about what I call the less tender interest objection. Okay. I don't think it helps to say that this is some kind of concerted attack on the press, a concerted attack on democracy. I think the bill needs recalibration in order to better strike the balance that it actually does try to strike. It's not great, it needs to be fixed. But that can actually be done reasonably easily. The first problem, Dario has mentioned, is the overbreadth of the controlling definition. This is crucial. An official secret has to say quite clearly what can be an official secret and what cannot. Everything else must be subject to freedom of information. And only a restricted class of defined stuff must be subject to classification. You've got to be able to say what it is, and crucially, you've got to draw those boundaries as precisely and as narrowly as possible. Okay. And it's a well-taken objection that the definitions in the 2010 version of the bill are overbroad. They will result in far too much stuff being classified, far more than is necessary or desirable. Okay. The solution to that, though, is to replace this rather vaguely worded stuff about the national interest and commercial information, etc., and replace it with the already existing grounds of refusal of access to information in the Promotion of Access to Information Act of Time. Those are beautifully calibrated, they have exactly the right thresholds that Dario was talking about, and they're reasonably tried and tested. They've been around for a while, and generally speaking, most people think that they are important to constitution. Here and there could be quite a lot. The Minister of State Security, when he made a speech on this stuff in Parliament on 17th September, seemed to say something along these lines. The definition of commercial information could be removed. Good idea. It shouldn't be there. The last thing we want to be doing is classifying commercial information. Some commercial information is sensitive and should be restricted. Right? People have to give you information, for example, laws compel drug companies to kind of give up their trade secrets to the government in the interest of regulation. Such information should be kept confidential. You shouldn't classify it. Classification is simply the wrong type of regime for that kind of information. But classification is for information which has a national security interest. Commercial information shouldn't be in there. And I think that point has been taken now by the department. The same would apply for the definition of national interest as an minister. A better alignment with the Promotion of Access to Information Act would be good. Yes, good idea. That'll do it. That'll fit. Simply use the provisions already existing in the Promotion of Information Act, section 46 through to 52, I think it is. It should do the job. The second objection relates to who decides on classification, and crucially, who can object to it. What can you do about it if you think if a Minister of Defense says, no, you can't do it, it's classified, and you say, well, we have to be able to object somewhere, this is an outlet. Right? Who can you object to? You need an independent perspective built into the system to prevent over-classification in the first place, and what's called cynical classification, the use of classification to hide embarrassing stuff. This is not what classification is for. Okay, so such a mechanism exists. It's to be found there in section 28, which we have no hope of reading. It simply says a request for access to a classified record made in terms of the Promotion of Access to Information Act must be dealt with in terms of that. If you want to see classified information, request it in terms of prior. Okay. You request it in terms of prior, then the prior and not the information bill applies to the division on its disclosure. Prior dispute resolutions will apply to such a request, internal appeals, and applications. So there is an outside independent perspective through the dispute resolutions provisions already provided for this time. There's also, there might even be something called an information regulator, and this is an issue I'm going to. Okay, the other point is that the public interest override will apply. Section 46 of the PIA, which says, despite all of the bases for refusal of access to information in the public interest, it can be referred. Section 46 is not totally perfect, it's a little too narrow, it was rather too narrowly drafted. Nevertheless, there is a public interest override, and the Minister of State Security seems to be saying, well, we like the idea of a public interest override, but not a public interest defense. In other words, you can't say, my defense for disclosing classified information, as Barry was saying, is that this is in the public interest. The Minister seems to be saying, you have to first access it, presumably through a prior request, where public interest override will apply. Draconian penalties, yes. I'll say one quick thing about them. These have been changed, and I think the reason for the change, you can't hope to see it. Section 40 of the 2008 bill versus Section 33 of the 2010 bill. The same provision, but they've been changed. First of all, to include a minimum sentence. The wrong or severe minimum sentence, I think, of 15 years. The previous bill simply said that the person will not proceeding from public license, you have to get 15 as a minimum. Okay? But the key difference between the two is that the first allows you to challenge the classification. To say, this should not have been classified. I disclosed it, but it's not a piece of information that, sorry, what are the words? Not a piece of information that is the disclosure which may cause serious or irreparable harm to the national relations of the public. That piece of legislative tinkering is ill-advised. Put back the old version of the penalties section, and the bill is clear. Conflict is inevitable. Okay, this bill will restrict freedom of information. That's what it's supposed to do. The question is whether it will restrict it in a way that does no more harm than is necessary for the achievement of its essential purpose.